Well, I think that a complaint has to be registered for your bill to take effect, doesn't it?
It has to be
Or
actually
an
someone going on
investigation.
probation.
Right. Now, I'm not sure that's the same as a patient just dropping out who is impaired. Good.
Through the chair,
Mr. Howard?
there's a space here between, I think, what Mr. Norm is saying and between the text of the bill and your question, Senator. The straight answer, as representative from CMA said, is there is no requirement that if someone withdraws or is kicked out of the program, that the patient be notified. That is not a requirement anywhere in this bill. It is also potentially the intent of the bill when someone who is in the program fails the requirements of the program to be notified, that the board be notified of that so that the board can take action potentially that might end up being disclosed. The problem that we have, and I hesitate to do this given the lateness of the hour, but given the importance of the bill, I can show you in the mock-up where the drafting problem is when it comes to the notification, because one provision, for example, of the bill unambiguously says that the uniform standards apply. That's great, because the uniform standards have in them different kinds of referrals to the board based on how the participant might fail. So, for example, the uniform standards say that the board must be notified when there are all violations of the program, not just treating a patient while you're drunk, or not just having a dirty test, but when you fail to show up for group, or when you fail to submit sufficient paperwork. All violations under the uniform standards have to be reported. But if you look at one of the provisions of the mock-up, it says the administering entity shall have a system for immediately reporting a physician or surgeon, that's good, who withdraws or is terminated from the program. Stop. That's just withdrawal and termination. Now, the uniform standards that are mentioned earlier would take care of that, but here in this section later on in the bill, it only says withdraws or terminated. Likewise, that same section, which is F on page 15 of your analysis in the mock-up, the administering entity shall not provide this information to any other individual or entity unless authorized by the physician. Stop. There's a uniform standard that says that under particular conditions, the hospital has to be notified. The supervisor has to be notified. So which one controls? The one that's later and more specific, or the earlier one that is more general but clearly comprehensive? So the protection against the absence of a patient being notified that a physician is in this program, and that, remember, this is a drug and alcohol addicted physician who's seeing our family members. The protection against being notified is absolute 1,000,000% clarity that the uniform standards apply. Why? Because that's how the medical board finds out about it, and that's how the medical board takes appropriate steps to make sure that the public is protected.
So just to follow up, Senator Galgiani, I'm sure that that's what you intend to have happen. I just need your assurance for me to support the bill, and I'm prepared to support it. I just need some assurance that that is in fact, you'll work with Mr. Howard, and that is in fact where you want to get. So these folks we've heard from who have been so severely injured by doctors who are either incompetent or inebriated or whatever will be protected. And with that assurance from you, I'm happy to support the bill.
Thank you, Senator Blanc. Senator Mendoza.
Thank you, Mr. Chair. First of all, I appreciate all the testimony today, and it's a very important bill. Obviously, this committee has demonstrated, especially last week's bill, we are definitely conscious and we recognize the need to protect our patients and our constituency. This bill is a little bit different in the sense that we're actually allowing an opportunity for doctors to step forward to get the treatment that they need so they could continue to treat our constituents. I do, understand we do have a doctor shortage in our state. We want to make sure we help the doctors that are in service right now. We want to keep them. We want to make sure they get the treatment that they need. I appreciate the author's willingness to work with the committee. I saw 4 pages of amendments that you're taking. For me, that tells me that you're willing to work with throughout the process, and I appreciate that. And I know this is not the only stop this bill is going to be taking, obviously. So I support the bill. I support your efforts, and I would like for you to continue, just like Senator Block said, to continue to work with opposition to make the bill better. And we will be there every step of the way. And Mr. Chair, I would love to move the bill.
Very good. Thank you, Senator Mendoza. I appreciate that. And I just wanted to say that over the last couple of weeks, we've worked very hard and with the CMA, with the author, to really look at, because it really is my intention as it relates to supporting a bill for physician, a wellness program that, especially with any confidentiality provisions, especially in light of my bill last week, that, I truly believe that if a person is not run afoul, has self-reported, and it's not, there has not been a problem with their employer, has not been a problem or a notification that their hospital, the medical board, or the law, that they should be able to seek help and support into this bill and a program like this bill proposes. It's only fair since a number of other professions, especially healing art boards, allow for this type of option for their licensees. But and as long as they the confidentiality should be allowed to remain in force to struggle through their substance abuse problem, as long as someone does not have a restriction on their license, on their practice, truly is not entering a program because of the hospital where they've been privileges told them that they had to enter a program, not enter it because the board told them as a condition of discipline. These individuals should be allowed to move forward with a program as long as there's that their hospital didn't, because of their actions, or maybe they're not performing up to the standard and the hospital says it. If it's at that point, then that needs to be reported to the board. But if they truly are self-reporting because they think it's in the right interest and they should have that, it really is not our place, I think to well, let me just say that it's, and I think that we, when it gets back to the issues that Mr. Howard raised, the 4 issues, and I think everyone in this room is on the same page. I frankly do, because I wouldn't support this unless it met those 14 standards, and one of those is the uniform standards that we talked about. And so if the language needs to be tweaked a little bit to make that clear, crystal clear, that it's the uniform standards, that's not a problem at all. It's not diversion. There's no diversion allowed in this at all. If someone poses a risk to patients at a hospital, and they cannot be an excuse to avoid the board, and they're going to have to go through it. It's also key that it ensures that the board will be made aware when a participant withdraws or has a problem of any nature, if they miss a test, because that's within the uniform standards. If they don't test, if they don't show up at the right time, if they don't do something, then they should go directly to the medical board and do not. Senator Wachowski, did you? Oh, they should not be allowed to continue. I think it's a starting point in the bill. I think there's some tweaks that need to be made. But when you look at your concerns, Mr. Howard, I know you have the uniform standards, the 4 issues, the program operator. Let me just talk about that for a second. I think it's difficult, and I would agree. I would hope and expect that the medical board and the general services, when they let the contract and do the bidding, that they would look at past performance as criteria when they do it, and they're not going to go in that direction. But I don't think it's the boards that we should be directing the medical board and DGS to tell them how to do this. I mean, that's their job, and at some point, if there's a problem, we will certainly be made aware of it, and we'll be right there, because this is such a difficult thing. So I think, here again, the concerns that you've raised, I think, are being addressed and will be in this, because I think that's our goal, and is to have something that will work. And I did want to say that there were the language that's proposed in the analysis, I think should be changed to further ensure that those uniform standards are correct. And I think that will be, and I think you're agreeable to do that we can make sure. And also that a physician surgeon with substance abuse issues can confidentially participate in the program only if they do not have a restriction against their practice. And I think that's another amendment that I want to make sure that you'll accept, and that's in the analysis today as well. So I think you'll be fine with that. So I think that we can move forward with this. I mean, I'm certainly comfortable with it because of the work, because of the commitment that we have. And I believe that certainly patient safety is the key. And I don't think that's a question. And with the amendments and the work that we've done, I'm certainly happy to vote for it. So yes, Senator Wachowski.
I don't want to douse any enthusiasm that people have. I just want to raise a cautionary concern, because I know from the diversion programs, not the diversion, the Prop 36 programs we had in court, I know one of the things that the judges would do when they were determining whether they were going to kick people out was that, did you take your, so some guy would show up at the meeting, he'd complete the meeting, so he'd have confirmation of that. He'd have confirmation that he took the drug test and he passed it, but he didn't check in. He didn't check in because part of the program that these folks have, because they want to keep people really in line, is that you got to check in. And sometimes, not that lawyers and doctors are pushy, but sometimes they just say, I'm late, I got to go into my counseling, or I got to take my drug test, and I do that, and I don't do the check-in. And I just, I know when we say we want to notify people when they fail and things like that, but I've seen judges kick people out of programs after they were at their meeting and didn't fail the drug test, but they didn't do the administrative check-in. And I just want to be cautioned that we're, in our enthusiasm, not that I'm batting for the docs, but maybe today I am, it's just that we be, let people succeed. Let's not try to find ways that they fail.
Through the chair, Senator, again, the uniform standards address precisely those kinds of issues. They identify major violations and minor ones, and they calibrate the menu of possible actions for the board to take or for the program to take based on whether they are minor or they are major. It's part of the reason why we're so adamant that the uniform standards apply, because they've been so scrubbed and thoughtful over the years that they address exactly contingencies like that.
And I have to say, and Senator Jackson, I have to say that in looking at the medical board, I thought they acted very responsibly in October when they drafted those 14 points. I mean, it really looked, I think they saw the problems of the past. They don't want to repeat them, and this was an example of that, Senator Jackson.
And I did want to just say, with respect to the medical board, I think they have to do their job. I think part of the problem is that there's some real question. They have to be a lot more, we're putting a lot of trust and confidence in the medical board to do its job, and I hope that they will do so. I've so far not been overwhelmed, especially listening to the testimony of these people today. The board has to be much more aggressive and work with the medical association, and certainly everyone's entitled to their due process. But remember, the goal is to do no harm. And with that, I will move the bill.
Very good. Thank you, Senator Jackson. We do have a motion, and on the bill, would you like to close, Senator Galgiani? Briefly, maybe?
I would like to thank the chair and the committee staff for working with us to come up with amendments that address the concerns, and you have my commitment that we will continue to work with you and the opposition to change and tweak the bill to some of the needs that were requested.
Very good. Thank you, Senator Galgiani. Galgiani, we do have a motion for Senator Jackson. Please call the roll.
Motion is due pass to Senate Judiciary Committee. Hill.
Aye.
Hill, aye. Bates. Aye. Bates, aye. Berryhill. Block. Aye. Block, aye. Galgiani.
Aye.
Galgiani, aye. Hernandez. Aye. Hernandez, aye. Jackson. Aye. Jackson, aye. Mendoza. Wachowski. Aye. Wachowski, aye.
7-0. We'll hold the roll open for absent members. Appreciate it. Thank you. Hey, don't leave a mic. Okay. Yes, Madam Chair, so item number 2. SB 1039, I will proceed. SB 1039 is an omnibus bill which includes several changes to a number of boards under the Department of Consumer Affairs and also includes specified fee increases for several boards, including the Board of Registered Nursing, the Pharmacy Board, the Contractor State License Board, and the Court Reporters Board. It will also eliminate a bureau under the department which registers telephone medical advice services. It is considered as no longer necessary because of the way in which individual boards deal with the requirements for medical advice services. For the dental board, under this measure, it will provide an opportunity for the board to approve a foreign dental school if they are accredited by an accreditation agency or commission recognized by the board. For the podiatric board, it will clarify that the board operates independent of the medical board. For the Board of Registered Nursing, it will provide for better oversight of the Board of Continuing Education program and providers. And for the Structural Pest Control Board, it will clarify the requirements for inspection and agreements made by the pest control operators and their companies. For boards that have proposed fee increases, they have submitted to the committee a fee bill worksheet to verify the need for any adjustments in fees. The information regarding the need for the fee increases and the actual increases proposed are reflected in the analysis. Some concerns have been raised regarding the dental board's approval of foreign schools. I have with me the executive officer of the dental board who can answer any questions you may have about providing the board with this additional authority to approve foreign dental schools. I also have author's amendments which I would like to accept at this time. The amendments reinstate provisions of law that affirm the licensure requirements for individuals providing telephone medical advice services and state that the responsibility for enforcing those provisions will lie with the licensing boards. I respectfully ask for an aye vote, members, on this measure.
Witnesses in support, proceed.
Laura Zuniga with the Contractor State License Board in support.
Medical Board is in support of the provisions that clarify that the Board of Podiatric Medicine has the authority to issue their own licenses, and we request your aye vote. Thank you.
Thank you.
Laura Parr on behalf of the Pest Control Operators of California in support.
Robert Lucas with the Structural Pest Control Board in support.
Additional witnesses in support? Witnesses in opposition?
So you'll be able to respond to his questions, his concerns, why you don't want to do it anymore.
Good afternoon, Mr. Chairman, Madam Vice Chair. My name is Richard Polanco. I'm a former member of this distinguished body. The bill before you has two sections. Section 1 of the bill is the dental scholarship fund that would be established. And obviously that is a very worthy public policy consideration, and we have no problem with that. I'm here today representing the Hispanic Dental Association, the Filipino Association, Dental Association, as well as the medical school in the Republic of Moldova. Very quickly, members, the bill was established by way of history. The bill, AB 1116, was established for purposes of allowing not so much the accreditation, but the equivalent standards to be approved by the dental board. And it did so back then because we were not going to lower the standards to foreign-trained dentists. And the difficulty for foreign-trained dentists has always been that after they've completed their 5 years abroad, in order for them to practice in California, they need an additional 2 years. And that costs today approximately $200,000. At least that is the cost at Loma Linda Dental School. The current program had broad-based support. It was sponsored by the department, it was sponsored by the California Dental Association. It had the broad-based support from a lot of stakeholders. It received only 4 votes. And the reason for bringing it forward was because there was a need to provide opportunity to students who were California-based, California citizens, wanting to study abroad. And AB 1116 ended up creating in statute a process whereby a foreign dental school could apply to the board for purposes of making sure that the statutory standards were being met. To date, that program has worked. Over 80 dentists, California students, have been licensed since the inception. And they have come back to California into districts where they are disadvantaged, lack of dentists, commonly referred to as health manpower shortage areas. What the bill attempts to do is to repeal the guts of the intent of the legislature in a measure that received but 4 votes opposing the bill. If you turn to page 8, the measure will allow the board to accept findings of CODA approved foreign dental schools in lieu of conducting its own evaluation. Current statute places that responsibility on this board. This would also alleviate, it states, the necessity of forming a technical advisory group, which adds an extra layer of review that is unnecessary. It is not an extra layer of review, and it is very necessary. Why? Because it is this body that is composed of dentists who will go and kick the tires at that university or that dental school. There's nothing wrong or broken with the current system. We could have done what is being proposed today back then. Today, existing law allows for CODA.
I think so.
We could have done what is being proposed today. The CODA was already in existence and therefore could have, but failed. They've been in existence since, as the analysis state, 1970 something. And very few accredited schools have come forth as a result. We're going to undo and have some unintended consequences that do not need to be there. And let me acknowledge that I want to thank the director of the dental board who is here today. We have been working with her with a current application. There have been but 2 applicants that have been engaged in this particular process. And I honestly believe, members, that what we are doing is going a little beyond. You'll have conflict with the policy of what is stated in the analysis on page 7, which basically says that the board, it is important to specify that the board does not accredit dental schools, but rather evaluates foreign dental schools in order to determine the education that is equivalent with the accredited institutions in the United States. That is very important language. Equivalent. You turn back to page 8 and it reads, once the international dental program meets the established criteria, consultation and accreditation services will be provided in accordance with CODA policy and procedure. You have 2 conflicting policy considerations here, members. And if we wanted quota to be that approving standard, it would have happened back then. We have what we have today, quite frankly, because quota was not living up and creating the kind of approvals for our dental schools. We have at least 5 universities or campuses that have dental programs today in California, if I'm not mistaken. You can count the number of students of color that every year are accepted and go through those programs. Here, under this program, in a very short period of time, we have tenfold that of what has been done in the last 5 years.
Senator Polanco, will ask Senator Hill to respond to that. Given the late hour, I think we need to hear if there's any other opposition. We know that you're focused on this particular section, and we'll have Senator Hill respond to that. Others in opposition? Then committee members?